anxiety out, and it's lower on each individual day. So, well done. Whenever you're ready. You good? Okay. Good afternoon, everyone. Welcome. It's a pleasure to have all of you with us for this inaugural event of the University of Illinois College of Law Jury Program. I'd like to begin by thanking Jim Walker, a member of the college's class of 1968, and his wife, Sharon, a 1967 graduate of this very university. It's their vision and support that made the establishment of the jury program possible. And we're deeply grateful for their generosity and commitment to this institution and to the legal system. And I believe that they are with us virtually, right? So a little bit more than in spirit, a little bit less than physically, but they're definitely here with us. I also want to thank Professor Suja Thomas for agreeing to serve as the program's inaugural director. Professor Thomas is a nationally recognized scholar of the jury and one of the leading voices on its role in the constitutional system. And her work has helped shape contemporary conversations about the importance of the civil jury, and her leadership will be instrumental in building a program of real national significance. Suja, thank you. Thank you for agreeing to do it. So the jury is more than a tool for disputes, more than a tool for resolving disagreements among neighbors. It's a cornerstone of our democracy and essential to the rule of law. It's an institution that embodies civic participation, impartiality, and public confidence in the justice system. And yet, despite its importance, the jury system is not always understood, and in some settings, it's used less frequently than it once was. So this program is designed to meet that moment. It'll bring together scholars, judges, and practitioners to deepen our understanding of the jury, provide students with meaningful exposure to jury processes, engage the public in conversations about its role and its future, and support research on the challenges and opportunities facing the jury system today. And above all, the program aims to protect the critical role that the jury plays in our legal system. In doing so, the program will help strengthen an institution that is absolutely fundamental to our democracy. So thank you all for being here today, and I'm happy to yield the podium to Professor Thomas. Suja? Congratulations.
Thanks to Dean Sharp. First, I want to acknowledge our distinguished guests who are here today. We have Judges Olmstead, Judge Lee, Judge Rosenbaum, and Judge Holloman. Thank you for being here. I'm sorry if I'm missing anyone, if any other judge is present today. So as Dean Sharp mentioned, the jury program was established to increase jury trials. I recall meeting the donors, Jim and Sharon Walker, about a year ago, when I shared with them my interest in juries and asked them to tell me about theirs. I learned about how Jim began representing plaintiffs in asbestos cases and how the Walkers struggled early and wondered if the firm representing some of the most vulnerable people in our society, such as people who had worked in harmful industrial settings, whether their firm, which must foot the bill, of course, whether it would survive. It did. They described how juries were essential to assess and punish corporations for wrongdoing. We see the success of the Walkers and other donors, but it is their very hard, difficult work from which we as a law school that we benefit, and the jury program is one of those programs. So another thanks to our donors, Jim and Sharon Walker. Our speaker for our first jury program event is Professor Valerie Hans. Professor Hans is the Charles F. Recklin Professor of Law at Cornell Law School. She is one of the foremost experts on the jury. She has authored several books on juries, including American Juries, The Verdict, The Jury System, Business on Trial, The Civil Jury and Corporate Responsibility, and Judging the Jury. She has been a leader in the legal profession as a president of the Law and Society Association, a huge association across the world. In addition to this talk, we have the pleasure of having her teach a class on the jury this week to our students. And today she'll be speaking about the vanishing jury. Please join me in welcoming Professor Valerie Hans.
Thank you so much for those lovely introductions, Dean Sharp and Suja Thomas. It's such an honor to be here with you today to inaugurate the new jury program at the University of Illinois. I know that you, Suja, have done an incredible job trying to bring this to fruition, and with the generosity of the Walkers, the launch of the jury program is really a gift to the nation, and I'm really excited to see how things develop. Today, I want to talk about what I consider to be a crisis, and which was alluded to in both of these introductory speeches, and that's the decline of the jury trial over time. I want to talk about the reasons why we're at this particular moment, and a little bit about what we are losing, and then speaking to the importance of the jury as an institution, I want to talk about what are some of the things that we might do to reverse the situation. So what I'm hoping to convince you is that America does need its citizens back in the courtroom. And I want to conclude my presentation today with some preliminary suggestions about what we might do to reverse course, how to reclaim the power of the jury box, and I hope we'll have some time for questions and comments because I'd love to get your ideas too. First, I want to simply give a little bit of the political background right now, the political context. The democracy meter, among other ways of measuring democracy in different societies around the world, has shown significant democratic backsliding in the United States at the national level. We see pressures on the federal courts, on the state courts, including increasing threats to judges. And what you see here is that the backsliding is both reflected in and perhaps exacerbates this confidence in major U.S. institutions. Here we have it by party, by political party, and you can see it's the same downward trend. Sure, there are little blips when a Democrat enters office of the president. Maybe the Democrats will feel slightly more confident. Same for the Republicans when one of their party takes over the presidency. But overall, you see really a tremendous decline, which is really concerning, and I want to say juries might be able to help with that. So the focus of my talk today is, and the urgent need for work like the jury program is going to be doing, is this decline in jury trials. And I want to begin with just a bit of data from on both criminal trials and civil trials to show you exactly what is happening here. This illustration shows the high proportion of federal defendants right now who plead guilty to charges and thus never have a trial. It's more difficult, these are federal cases, it's more difficult to collect information from state courts, although we have a little bit, but from what we can tell, very similar patterns in state courts with the vast majority of defendants pleading guilty rather than going to trial. And that is a decline from just a few decades ago. You can see back in the 1970s, about 15%, again, in federal criminal defendants would actually go to trial. By the mid-'80s, it was down to about 8%, and 2015, 2.9%. It has been between 2 and 3% with a big hit from COVID. What's the reason for that? Many people have talked about the features of the criminal justice system and sentencing that have contributed to that, but I think everyone agrees. I don't know if we have any prosecutors in the audience, but prosecutors, if you are prosecutors, you know you are the most powerful actors in plea negotiations, whether or not people, the defendants you face, are going to go to trial. That power comes from a number of different mechanisms that were introduced over the last several decades, including mandatory minimum sentences, which I think legislators rightly thought, oh, here's a vehicle for us to really target people who are most culpable and most deserving of punishment. However, if anyone is charged with a crime with a mandatory minimum sentence of imprisonment, that's a very powerful tool on the other side. Sentencing guidelines are also quite potent. There's a psychological phenomenon called anchoring, and as I understand, at least in the federal system, judges are required to begin their sentencing analysis by looking at sentencing guideline highs and lows, and those can, in fact, anchor what a judge might consider to be an appropriate sentence for an individual. And finally, trial penalties really discourage defendants from pursuing trial. All of that has left a shift in the judicial role from presiding over trials to managing pleas. And I'd be very interested in hearing the judges reflect on whether this reflects their experience. The trial penalty is, and mandatory minimums, trial penalties, and sentencing guideline threats are so powerful that the National Registry of Exonerations and the Innocence Project, both of whom count how many innocent people who are exonerated pled guilty at their trials, have reported over 300 cases of individuals who did not commit the crime for which they were charged, but nonetheless have wound up pleading guilty because it seemed like the rational thing to do. And if you wonder why anybody would do this, I have this from a really fascinating piece by a report by the National Association of Criminal Defense Attorneys. They published in 2018 called The Trial Penalty, easily available online. One of the things you can see here is that those who go to trial would get something like twice or more in terms of imprisonment of what they would get in terms of plea bargaining. We'll return to this toward the end of the talk when I discuss what might be done to kind of counteract some of the things that contribute to the trial penalty being so dramatic. Switching to civil trials, in this slide, this extends some data that I collected and analyzed with another scholar, another jury scholar, Richard Jolly, and a litigator, Bob Peck. You can see the evidence over time and the percent of trials. I mean, what is remarkable here is it's not just juries, it's any trials, right? The blue line is bench trials, and they also went from, in 1962, when there was first reliable information about the rate of trials, they were about 6 to 7% in that first decade, but you can see they really collapsed over time. And jury trials showed the same kind of pattern. Jury trials are a bit more likely to in later years have kind of eclipsed bench trials, but only slightly. But what is most remarkable, I think, here is this incredible decline. So now we are probably between 1% and nothing. And what I want to do in this slide is to show you it's not just a percentage. I mean, you could imagine, oh, maybe there are huge numbers of new filings, and so the rates go down, but there are still lots of trials. No, that isn't happening. I mean, there might be more. Indeed, there are many more cases in some years, but what you see here is these are the number of civil trials per Article 3 judgeship. And you can see that just 10, 15 trials during the 1960s throughout up till about the 1980s. But now, number of trials or jury trials by federal judges is just about 1 or 2 per year. Now, there's so many more trials in state courts than in federal courts, so I went to the National Center for State Courts to take a look at data. These are from their civil jury trials. These are 7 states that, unfortunately not including Illinois, but from 2012 to 2023, these were the ones that actually collected data reliably and reported it to the National Center for State Courts. What you see is some slight declines from 2012 to 2019. Obviously, a huge dip in 2020 from the pandemic. But one of the worrisome things you see after that is that there has been a rebound, but none of the states have as many cases as they did before the pandemic. So it seems as though there was a big hit in the pandemic, and that led further to this decline. So civil cases, when we talked a little bit about why defendants might be extremely interested in pleading guilty, and might be rational, in fact, for doing that, even those who might be innocent of the crimes for which they have been charged. But what about litigants choosing alternatives to a civil jury trial? So many litigants are opting out. Well, we have some information, I think pretty good information about their reasons from a terrific survey of judges and attorneys that my co-author and collaborator Sherry Diamond and Jessica Salerno undertook in conjunction with the American Bar Association. Diamond and Salerno asked judges and lawyers about their preferences for different ways of resolving disputes and then different features of those ways of resolving disputes. And I'll show you this on the next slide. I mean, lots of bars here, so let me walk you through it. You can see here the characteristics of the different types of civil case resolution procedures, and then you can also see the different types of resolution: arbitration, mediation, a jury trial, and a bench trial. So the jury trial is like 3 in, right? We start with arbitration, then mediation, jury trial, bench trial. I think there's so many things that are really fascinating about this slide. Totally not surprising that it would be good if you could mediate a resolution to your own dispute. I mean, you know, it's understandable. That could be predictable, quick, cost-effective, fair, and you would prefer it. That is not at all a surprise to me. What is intriguing is where the jury fits here. It is less predictable. It is the slowest. It is the least cost-effective, but fairest after mediation, and also preference, the preference of lawyers and judges expressing their views. So it's the case that jury trials are also, because they're seen as, you know, less predictable and more costly and taking a long time, but more fair, and what would be a preference. Let me say, when they did break down the preferences by judge and lawyers, the judges did not think the bench trials were not as fair as jury trials. Just saying, you know, maybe they had some special insight about that. So what's caused this reduction in civil jury trial rates? Much of this is captured so beautifully in Suja Thomas's amazing book, The Missing American Jury. And in fact, I have a little picture of it right here. Congratulations, Suja, on that phenomenal work. Really, really amazing. It's the federal rules of civil procedure, really right from the start, but also changes to those rules in the name of efficiency have actually wound up producing many roadblocks to jury trial in civil cases. I mean, right from the start, the rules introduce this requirement that a litigant has to affirmatively request a jury trial within a very short period of time, and many people miss it. Otherwise, the case would by default be heard by a judge. I don't know how many subscriptions all of you continue to subscribe to month after month after month. But anyway, maybe it's just me, but default rules can be extremely powerful. And I think we see at least one reason why civil jury trials are rare. But federal rules over the years have also promoted the idea of judges as kind of managers who should move cases efficiently through their courtrooms. And jury trials, as we know, are not the most efficient option. But powerfully, rule changes have also facilitated really substantial increase in motions to dismiss and summary judgments. And in fact, right now in the federal courts, it's about 1 out of every 5 cases in the federal courts is resolved through summary judgment, meaning it never gets to the jury. The judge has to imagine what a jury might think of the credibility and power of the evidence in the case, and has to kind of intuit what that might be. Increasingly difficult if there are few jury trials. Also, we have to mention mandatory binding arbitration, which has risen astronomically as businesses have increasingly introduced binding arbitration clauses in their consumer and employment contracts. It kills me every time I have to sign on the dotted line, or actually just click, because there is a binding arbitration clause in something that I actually really want to do or to subscribe to. But I do it because I have no choice. Also, I want to say there are a number of individuals, many people in the insurance and business community who are worried and scared about juries. And some of that may be based on cases they have lost in the courts, but as a result, there have been attacks on the abilities of the civil jury, attacks that have convinced legislators quite persuasively to impose damage caps on the civil jury, limits on punitive damages, some on non-economic damages. Thank you, Suja, for illustrating all of that for us and letting us know what some of the consequences and reasons are for the decline. I want to say one small thing. In addition to there being many fewer jury trials, the National Center for State Courts and a couple of other organizations are also noticing that it is harder to get people to come to jury duty. So even though there's much less demand on the citizenry than there was before, we still see some real declines, which may have to do, again, with the kind of overall declining confidence in institutions that I began the talk with. Having described these declines, I do want to give a pitch for the importance of trial by jury. And I think the body of research that scholars have done over the decades illustrates, I think, that we're losing a lot by not having juries. So as a kind of overview, transparent and public resolution of legal disputes, I think Dean Sharp, you really spoke powerfully to that. Something I've studied myself, the fact-finding advantages of juries. If they can be drawn from a representative cross-section, they're actually kind of, perhaps to some people, surprisingly a strong form of accurate decision-making. A chance to actually educate our citizens about the law. And an interesting effect, documented now by research, of the positive effects of serving on a jury on the people themselves who serve. So not only what the jury does for the legal system, but actually what experiencing a decision-making role in the legal system does for the people who are in it. So first, just talk about why juries actually many times are very strong decision makers. Not that they can't make mistakes, everybody makes mistakes, but part of what we learn here is from the field of social psychology, which studies decision making in groups. And it's got the kind of group nature of decision making allows people to exchange information and perspectives, and allows people to kind of test out how they are interpreting evidence in a case. It allows people to share work in a collaborative project that they're all doing together. Each may have some special insights. The other thing, and I think this helps to explain why serving on a jury actually has effects on the people who do it, participating in a group can lead to significant change of attitudes and sometimes even behaviors. And I'll give just one example. It's a favorite example of mine from a researcher named Sam Summers, sadly, who passed away this year. Terrific social psychologist, very interested in psychology and law. And he did really a fascinating research project using a mock jury research methodology where you bring people from the community into the laboratory, and what he did was he was in the Detroit area, and what he did was to form people into groups of two different types. One type was all white, 6-person jury. The other type was a diverse jury with 4 whites and 2 African Americans. What they did was they listened to a legal case, a criminal case, which was a sexual assault with a black defendant and a white victim. And what Summers did was then compare the jury's judgments and deliberations. And he discovered that being in a diverse jury, the group on the bottom, 4 whites, 2 African Americans, had some striking effects. First of all, black and white people responded differently to the case. So you see the 2 black jurors, right? The black jurors on diverse juries wound up least likely to initially make a decision that the evidence was sufficient to merit a conviction. Whites were more likely to think that the evidence merited a conviction. But what you can see here, it actually depended on whether they were in a diverse jury or an all-white jury. So their judgments really depended on anticipating deliberating. So this is before any deliberation has occurred. They simply know that they are going to be in a deliberation and it's going to be diverse. I think one of the things that I was intrigued by is that he analyzed the deliberations of these 2 types of juries. And the diverse juries had longer deliberations, and they discussed more facts about the case, and they were actually more accurate too. And the difference wasn't simply that black jurors were on diverse juries and they made distinctive contributions, although they definitely did. But as you can see here by the bolded numbers on the left, on the 2 right columns, whites in diverse juries mentioned more novel case facts, were more accurate, and raised questions about missing evidence more than their counterparts in all white juries. Interesting. So in addition to creating conditions for more accurate fact-finding, there are other benefits to representative juries, such as public confidence. When verdicts, especially in racially charged cases, seem like inconsistent with the facts, a diverse jury can increase perceptions of fairness. Jurors typically have more positive views of the courts following their service, especially among racial minorities. So jury service winds up educating people about the law and boosts voting and other forms of civic engagement, as I'd like to show you. Been lots and lots of surveys on jurors. I've done some myself, and routinely, after service, people become more favorable about the jury system once they have served. And it's really rather remarkable to see the kind of positive boost. Those who serve as jurors are also more likely to see the courts as fair and just. I mean, think about it. I mean, what kind of information do people have about the courts generally? I mean, they see what's on television and social media. And very little of their own direct experience. But serving as a juror, they get to see up close the judge presiding over the trial, the routine of the trial, the way in which both sides present information and arguments, and the deliberate way in which a trial is typically conducted. And that lets them that leaves them with a more positive view of the courts than they might see otherwise. Let me just say, we're talking about the American jury here. I'm currently working on what is, to me, like an absolutely fascinating project. The country of Argentina has moved toward including juries. As you might know, their military dictatorship did in the 1970s was a difficult time for that country. There was collusion with judges who were serving at that time, and that was really a death knell to confidence in the judiciary. So once Argentina turned toward democracy, they did not actually change their views, and confidence in the courts there and the judiciary is very, very low. And people said, what about juries? Let's try. If we don't like what judges are doing here, let's add juries. So I've been fortunate enough to collaborate with people there, and we have found that basically people knew nothing about juries. They didn't even know their province had juries when they were summoned for jury duty. So absolutely unclear to them that they would ever be deciding a case. But they came out with greater positivity about the jury system, and also about the courts and the judiciary and even the government. So it was, I think, when I and others have presented these data to the courts, including the judiciary and litigants, I think they are, satisfied that at least one step at a time, they're moving in the right direction. Back to America, a recent survey done just in 2023 shows that if you compare everyone who has served as a juror to the general public and ask them about the trust in the jury system and the courts, you see, lots of people saying fair amount, but obviously what you see here with the orange bars is more faith, more trust in the jury system and in the courts among people who have actually been there. Our U.S. Supreme Court praises the democratic benefits of jury service. It appears this experience of serving on a jury does boost what is already significant public support for the justice. But I've always liked this quote from Powers versus Ohio. The judges write about the importance of the jury in our system of justice, underscoring that the presence of the jury in a justice system, to the extent that it is procedurally just, ensures respect and continued acceptance of the law. And speaking about respect for the law and engagement in the civic enterprise that we are all in our democracy, several researchers have done some absolutely fascinating work, starting with an initial project in Thurston County, Washington. They combined information from voting lists and the likelihood of somebody voting and whether or not they voted in past elections and future elections, and jury service. What they discovered is in Washington, this particular county, less than half of the people who were registered to vote, so these are citizens, and in this particular election, less than half of them voted. I know it's our shame as a country, we don't have close to 100%. Then they looked at what happened to individuals who had some sort of jury experience. And they divided them between jurors who had, for some reason unrelated to their inability to arrive at a verdict, had so-called inconclusive experiences. So perhaps there was a mistrial for a reason not related to jury conduct. There was no difference between those jurors and the ones who were registered. But when they reached a verdict, it shot up a significant 10%. So it really boosted voter turnout after the experience of serving on a criminal jury. And it makes sense. Civic engagement leads to more civic engagement. And they were inspired to take that one project in one county and examine it throughout the nation in, I believe it's 7 different locations with a total of 13,000 American jurors in different cities. An extraordinary project. And they found that the very people we are worried about the most, and the parties are out there trying to get these people to vote for them, of course. The infrequent voters who sometimes vote, sometimes don't vote, those individuals who deliberated on a criminal jury were more likely to vote in the next election. I teamed up with John Gastel and his collaborators and one of his students to look at what happened with civil jury service. One of the things we discovered was we looked at all we did not divide it between infrequent and frequent voters, but we discovered that civil juries who served on jurors who served on what you would call a typical jury, a 12-person jury that had to reach a unanimous verdict. Those were the individuals who were more likely to vote in the next election. And that's important because throughout the country, there are a number of states who have civil juries of size 6 or maybe 8. In many instances, they are not, if it's a 12-person jury, they're not required to be unanimous. So it seems like this voting boost really comes from this intense experience of working with others and attempting to get unanimous decision in a case. Can't talk about juries without the French thinker Alexis de Tocqueville, who many years ago in the 1800s visited the United States and was very impressed with the jury and was quite eloquent about it. He argues that the jury, and most especially the civil jury, serves to communicate the spirit of the judges to the minds of all the citizens. And I think one of the things I really like here about his quote is he shows that when you participate, or this was his observation, when you participate, you experience that being a citizen has duties, and the duties really cement your bonds with the country. So for those of us concerned about democratic backsliding, trial by jury can serve as a counterweight. So what can we do? I have just a few suggestions. I would love to hear yours. And one of the tasks that I am giving my students in the course that I'll be teaching this week here at the University of Illinois College of Law is to come up with reforms themselves and write research papers on them. So I'm optimistic about that. But here's a kind of an overview of what I think could be some next steps and research-based recommendations for strengthening the jury system and correcting this slide downward. First, we could strengthen juries. We do know there's been lots and lots of research now on juries and how to promote even stronger fact-finding. We can reform jury selection so that it maximizes the chance of achieving representative cross-sections of the community. I'm a big fan of 12-person juries. I know they're twice as big and it takes more time to get to the 12, but there have been, I think, many research studies now showing that 12-person juries are much better at representing the full community, engage in lengthier and more robust deliberation. So that's definitely something that I would like to see. There are also ways in which we could reform the jury selection process. Heard a talk just a week or two ago about from Jessica Salerno, now a psychologist working at Cornell, who argues our jury selection methods were developed in a time before we really knew much about prejudice and how it develops. We didn't know anything about so-called implicit bias that psychologists have now been studying for decades. And we should think about reforming the way in which courtrooms select juries to make sure that they're fair and open-minded and able to do a good job. And furthermore, and this is something that, warms my scholar's heart, test whether or not these different reforms actually have the intended effects. The other thing where there's lots of research on is encouraging jurors to take notes, to even ask questions in a very controlled way, should they have trouble, especially in complex cases. Adopting so-called active jury reforms. As for the criminal law, I drew on the National Association of Criminal Defense Attorneys' great essay report on the trial penalty. They recommend doing something about mandatory minimum sentences. Of course, they are defense attorneys, right? They would like to see all those sentencing statutes repealed. If that is not an achievable goal, so I think they are realists as opposed to, just a head in the stand. What about a judicial safety valve? Like there is with the sentencing guidelines, right? There are sentencing guidelines that allow deviation from the guidelines, and why shouldn't there be that with mandatory minimum sentencing statutes? One of the things about plea bargaining is it often does not permit a defendant and the defense attorney to have a good sense about the evidence on the other side against the defendant. And so the defense attorneys would love to see full discovery before they enter any guilty plea. That is more work on the prosecution side, so I'd love to know what prosecutors think about that. But in particular, they want to be sure to try to think about procedures that we could introduce that might address the trial penalty issue. So, for example, one of the things that is attractive about a plea from the perspective of the person doing the sentencing is that by pleading guilty, the person has acknowledged responsibility for the crime. What about, the defense attorneys argue, what about allowing an opportunity for defendants to do that even if they do choose to go to trial? The other thing that one could do is, in addition to allowing for an opportunity to engage in responsibility, even if you select a trial as opposed to a plea, compare sentences for example, co-defendants, to ensure that the person who is selecting a trial does not get a significantly longer sentence, which, depending on the nature of their contributions. On civil trials, Richard Jolly, Bob Peck, and I proposed a number of things. We would like to get rid of that default rule, the jury trial default rule. Why shouldn't the default be trial by jury that you default into if you don't get around within the very short period of time that you have to select a jury trial? Removing damage caps and caps both for punitive damages, non-economic damages, would be attractive to plaintiffs' attorneys because it would provide them with incentive for actually pursuing a case. And another thing we suggested, looking back at the reasons why people describe juries, as inefficient, taking a long time. What about expedited jury trials? There are experiments with, I use the term experiments loosely here. There are experiments with expedited jury trials. Often they have 4 people or 3 people sit and listen to an afternoon of evidence and arguments and then discuss, and the results are non-binding. So if we were going to be designing an expedited jury trial, we wouldn't do that. We would say, hey, let's bring in 12 people and make sure you're representing a broader range of the community, so that at least you've got a sense about community judgment before you use an expedited jury trial, perhaps even as a vehicle to settle the case. Who knows? So those are some quick ideas, but I am looking forward to the students in my class coming up with some more ideas. And I'm eager to hear some of yours. Thank you. I would love to take questions and comments and suggestions for reform. I understand there is a microphone, and if you would like to make comments or questions, you need to press a button on I think it's on the top, and then your voice will be magnified.
Okay, hi Professor, thanks for coming. My name's Tyler. Last summer I interned in Clark County, Washington, so pretty close to Thurston County. And while I was there, we had, I worked in district court, had a whole docket. We had 3 deputy prosecuting attorneys who prosecuted misdemeanors and gross misdemeanors. And then we had myself and 1 other intern who were licensed to practice under supervision. So we ended up doing a lot of plea bargaining. And, we were certainly open to jury trials. It's the defendant's right to exercise that. But I think for me, in my personal experience over the summer, a lot of it came down to the money. We had basically only 5 people who were capable of prosecuting a crime in the state's, depending on the year, the 3rd or 4th most populous county in the state. And we would go to court and we'd have a severe shortage of public defenders. We would have I think we had 6 district court judges and 2 commissioners. We had a courthouse where, at the time, there were only 3 courtrooms that were available for use. So I think, even if we all aspired to the jury trial, I think it came down to the money. We had too few prosecutors, too few public defenders, and too few judges to hear these cases. And I guess my question for you is, if you're somebody who's not invested in democracy, and if you're somebody who doesn't care about criminal defendants, I guess I just don't understand how you would motivate the community to say, we need more resources for the court, for prosecutors, and for public defenders, because maybe that's how you distribute justice.
Yeah. Oh, thank you for that excellent comment. That's really fantastic. And I think I agree with your analysis that we need more funding for the courts. What's interesting to me is that you said it's actually for all of the individuals, the judges, the prosecutors, and the public defenders. All of those were in short supply. If you were to take everyone to trial, did you have any trials?
Yeah, I was second chair for jury trial in which we received a conviction on both counts. One charge was for concealed carrying of a firearm without a license, and the other was driving with a suspended license in the 3rd degree. The jury asked a question about, because the defendant represented himself pro se, and he made some comment about a matter of law, and the judge instructed the jury to disregard that, but then the jury went and deliberated for about an hour about whether or not, because he asserted his right to carry a firearm would preclude the charge. And after the judge instructed them to disregard what he said about that, they came back in 10 minutes with a verdict. And then I prepared a few other cases to go to trial as first chair, and they got continued until after I returned to school, so it's just not possible to prosecute. But
Yeah. So let me just say, I am thrilled that you actually got experience serving as second chair on a jury trial. I mean, that's really unusual. I know so many of my students at Cornell, where I teach, except not this week. This is our spring break. But so many of them are unlikely to have the opportunity. And, if people like you don't get a chance to actually participate as litigators in a jury trial, maybe there'll be a moment where you're sitting there going, oh, do I want to do a jury trial when I've never done that, or I have inadequate training on jury trial. I know you have a great trial advocacy program here, but being actually in the trenches and being able to do cases yourself, I think is really an incredible part of being a lawyer. And if we don't have people who feel confident in their own skills to do that, I think we're in trouble. And those are going to be the lawyers who say, let's get a settlement. Let's work a little harder on getting a plea.
Yeah.
In this case.
If I may add, just
Sure.
apropos all of the plea deals that we negotiated with the defense attorneys,
Yeah.
I think in my experience, probably 95% of the cases that I worked on, the guilt of the defendant was unmistakable and uncontroverted. I mean, it'd be something where a defendant would get caught red-handed, and then they would confess to the crime, and then it's like there's nothing to really try in a case. You have a admission by the defendant. So I think when you had, for us, maybe it was not like an explicit pressure to settle cases, but when you only have really 5 people who could possibly prosecute a case, and you have so many cases where the defense or the defendant is just so overwhelmingly guilty. It's like, I think the defense is focused on where can we actually score a W, and that's why I felt like most of the pleas, or most of the cases ended up getting pleaded out.
Thank you. Yeah. 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 There's
there
that
we
button
go.
on the top. Yeah.
So I was wondering if you could expand on the expedited civil jury trial that you mentioned, because it feels like having like these small juries for civil trials kind of feels similar to what the types of things that trial scientists do to like research and determine how best pick jurors. And in my personal view, if it's not binding and it's just a small jury, it doesn't feel like it's going to have the same civil engagement benefits.
Yeah. Thanks so much for that question. Who are you?
Oh, sorry, I'm Thomas.
Thomas, okay. So Thomas, the idea of the expedited jury trial is trying to address the concern that a lot of people have for inefficiencies of juries and probably finances too. There are some jurisdictions that have experimented and use the expedited version that I was talking about, with small numbers of jurors hearing maybe just an afternoon of comments and questions and arguments in a case that otherwise might last a few weeks. I mean, something pretty complicated. That could be binding if they wanted, but often it is done simply as a route to settlement. So what we proposed in the article, like Richard Jolly, Bob Peck, and I proposed in our article, was refashioning the expedited jury trial to take advantage of the idea of miniaturizing the case in a way to the key arguments or the central issues in the case, but then using a real jury. I mean, using what would be the kind of jury you would have in an ordinary jury trial, so as to get those group decision-making benefits. I do think you're right that if you are participating in something that you feel is binding, and you deliberate ferociously to an end, that's probably most likely to give the civic education benefits that you are alluding to. I think that's exactly right. So if you re-envision expedited trials, you might, eliminate some of the problem of extended jury trials being too costly for people, but also would preserve a community voice.
Thank you.
Thank you. It's the button on the top. The button on the top.
There we go.
Yeah. Thank you.
I'm Verity Winship. I'm a professor here. And I just have a question about whether you have thought about or can say a couple words about optimum amount. So more is the theme, right? More than we have right now. But is part of that a vision of how much we should have in this system of jury trials, and what kind of categories do you think we should be treating in this way or channeling in that way? Thanks.
So I know your work. It's fantastic. So happy to have this question from you. So in terms of amount, I don't have a specific amount. I think 5 or 6% of the cases, it kind of depends on how many you start with, how many cases you start with, but 5 or 6% of the cases. So you feel like, well, this is a reasonable opportunity that people can have, not something that is, vanishingly small, like less than 1%. So I'd like to see a boost up to that amount. And I think many of the factors that Tyler talked about, that is, the options for the defendant might be very limited, and going to trial versus plea bargaining might not create a difference in terms of the evidence that would be developed in a particular case, might factor in there, and keep it as low as 5 or 6%. In terms of types of cases, I think this is a really interesting question. I mean, do you want juries for small cases, misdemeanors? Do you want that opportunity, or do you want to really preserve jury trial for serious cases where the government has an opportunity to either sentence to death or remove liberty for an extended period of time? And I think certainly you want that. I think in civil cases, there are similar kinds of issues, and I like to preserve jury trial for the most complicated and the most significant trials involving, for example, business litigants whose actions might affect large numbers of people. So if I had to cut off trial by jury, I think I would follow, what the courts and the Constitution have already kind of set out for us. More serious cases, ones that have more impact on individuals. But I'd love to know what your percentage might be if you were thinking.
Well, I think we're at our end, unfortunately, and I just want to thank Professor Hans for this wonderful talk, and please join me in thanking her.
Thank you all so much.
So we got some questions.
Thank you for doing that.
Yeah.
Fantastic.
Yeah.
That was wonderful.
Oh, thank you. Thank you so much. It was nice of you to stick in there and stay.
No, I was happy to do it. Since you wouldn't forgive me. She tells me I need as much education as I can get.
Yeah.
So I said, so I was wondering, do you know